Okay, I did not see that coming. Hi folks, Tony DeWitt again with another video on the law. Remember, I don't dispense legal advice here, and this is what we're talking about today. So a funny thing happened on the way to this video today. Maybe it's funny, maybe it's only funny to me, but every now and again, my wife will have something that comes up at work that requires me to come in and work with her on something. Usually it involves some issue that relates to both healthcare and law. And so I will go in and work with her and try to get the problem solved or make recommendations, whatever I need to do. And so last night, while I was planning to do this video, the wife asked me if I would go to work with her tomorrow. And hey, we'll go to the Chinese restaurant for lunch afterwards. I'm like, okay, I'll do that. And like everything else, we were supposed to leave at noon. It didn't quite happen. We got later and later. And finally, I got home. It's 2 o'clock. I'm getting ready to put the video together. And I get a notification from YouTube that says, hey, guess what? There's a verdict. So I went and looked at the verdict. And man, am I ever glad I did, because the video that I would have done otherwise would have talked about the closings. And it would have said that, after my initial thought that maybe the state didn't do such a hot job on the closing, I had looked at some of the clips and I thought, well, it's a B minus. As so often happens, your first reaction is usually the right reaction, and when you go back and reconsider, a lot of times you just confuse yourself. I should probably remember that going forward. The problem is that the defense is closing, and their work throughout the bottom of the entirety of the case has been pretty good. They have attacked the evidence that they could attack, and they've left the evidence that they couldn't attack alone, which is a good strategy, particularly when you have a self-defense case, because the only thing you have to do is raise reasonable doubt about self-defense. Now, I honestly believed that this would have been a guilty verdict if I'd been on the jury. I don't know that for sure because I didn't sit through all of the testimony, only sat through a little bit of it, but I did see the ME and that kind of thing. And I just believe that the presence of defensive wounds sort of ruled out any idea of it not being a homicide. But for whatever reason, I'm pretty sure I would have voted to convict, but that's just me. There are a lot of people in the days to come that will blame these defense attorneys for this verdict. And they absolutely should not blame the defense attorneys for this verdict. The defense attorneys did exactly what defense attorneys have been doing since there were defense attorneys. They have been advocating on behalf of their client, and they've been doing it in a strategic way and a way that I kind of felt was off-putting. It certainly bothered me that they were dumping a truckload of dirt onto a poor dead woman, but apparently it had the effect that they intended, because the jury let this kid walk on both the kidnapping and the murder. And how I have yet to see how anybody could honestly believe that if you were lunging at someone with a knife with your hand out, that you could then somehow fall on the knife, pull it back, and shove it through your neck. I don't get that. But hey, I'm not a biomechanical expert either. And of course, the defense did not have a burden. They didn't have to prove a blasted thing in this case. And I don't think they did. But the prosecution did have a burden, and I think they took the case much too lightly. First of all, they did not properly staff the case. You saw one attorney and one attorney only, and pretty much any issue that came up, well, Judge, I trust your ruling. I trust your decision. And that's nice if you have a good relationship with the judge and you really do trust it. But if you don't really understand the issues, or you are not good about on the law, then you need to be able to tell somebody that you work with, hey, you need to come help me with this, because I think he blew several of the more important motion parts of this case, where the defense moved to keep stuff out, where I thought he had a pretty good argument for getting things in, but then he lost on those motions. And it could be just that the judge hates the guy. I don't know. If he does, it doesn't show. The judge didn't seem to me to manifest any animus against him. So, maybe that's not the case. But I do think that the state took this case too lightly. And by that, I mean, when the opening statement was delivered, there was not very much passion in it. And when the closing argument was delivered, there wasn't nearly enough passion in that closing. When you are the prosecution, when you're the state, you are speaking for a victim. And the victim you're speaking for is dead. She can't speak for herself. So you have to manifest the outrage that she would feel by being killed by her own son. Now, I think at times he came close to that. Here's a clip where he did.
So what happens? Who's doing violence to who? I ask you that. Who is being violent to who? The mom is not being violent in any way, shape, or form to her son. She is doing nothing to him. Nothing to him. But good old Colin Griffith grabs his mom and he yanks her, he pulls her, he drags her. Who cares what verb you want to use? The point of the story is that he pulled her and dragged her into the house. She didn't have a choice because her hair was being pulled and her head and her body was being dragged into the house. Why did the defendant do that? Because he was about to unleash and quench his bloodlust for his mom. He was going to accomplish what he wanted to do for whatever it was, weeks, months, a year. And his bloodlust was going to be quenched at the price and at the cost of his mom and her dignity and her life.
But for the most part, I think he probably did not get the job done. And I don't know that there was a problem with the evidence. I think he got in all the evidence that he needed to get in. If he got in the evidence and he got past the motion for an acquittal, then it seems to me that if there was a defect, it was a defect in rhetoric. It was a defect in being able to communicate to the jury what they needed to know to find this young man guilty. Now, there is a possibility in this world that he is factually innocent. I can't discount that. That's what the jury found. I respect their verdict. It's really, really hard when you're the prosecutor in this case, knowing what you know, believing, I'm sure, that you think a grave injustice has been done here. It's really hard to let that go. This will sit with this guy for quite a while. He'll be incensed by it for a long time. I know, because when I've had similar situations, I have been incensed, and it takes you a while to get over it. But my old boss used to say, okay, you've spent, a year and a half filling this bathtub up to the top, and you put on the best case that you could, and you lost, and now you got to drain the bathtub and let all of that go. And that's what he'll have to do at some point. He'll have to drain the bathtub, let all of that go. The defense attorneys, if they were really smart, would go out and interview the jury. And of course, so would the prosecution. They would go interview the jury and find out what it was that made the difference, what piece of information was lacking, what turn of phrase maybe caused them not to believe a witness or whatever. That was primarily the defense's attack. It was a defense that attacked the witness, Robert Willantis, the grandfather. It attacked the decedent. It beat her up terribly. It emphasized the close relationship with the grandmother and how much she loved the grandson. Okay, that's smart too. And then it essentially didn't attack the other evidence. It just said, we have a different explanation. And different explanation carried the day. It didn't hurt that you have a clean cut young man wearing glasses who looks a little nerdy sitting behind you. Now, some people might believe that he is a successful serial killer at this because he killed both his mom and his dad at this point. The jury didn't know that. If the jury had known that, maybe they would have reached a different decision. I don't know. But he's killed his mom and his dad, and a lot of times, and I'm not saying that he would do this, but I'm saying that a lot of times, once somebody gets a taste of what it's like to take a human life, as some of those statements that were allegedly made to the grandfather might illustrate, they like it. They find that they enjoy that godlike power of depriving someone of their very existence. And if that's the case, if that's the kind of thing that he feels at this point, then you can look for him to be in the dock again at some point, because if indeed that's where he is going, then he will probably reoffend. And of course, if you want to think of it this way, there is a strong possibility that Oklahoma will reindict him and go after him based on what he said to, among other things, Robert Willantes. I don't know that for sure, but certainly they may feel that a grave miscarriage of justice has occurred here, and they may decide, hey, we've got a case against him, and there is no statute of limitations on murder. So that's what I have for you today. It's a little bit shorter video just because I'm not going to throw a lot of video up there because the case is over, and um, I think the Law and Crime says it was a shocking verdict. I don't really think it was a shocking verdict. I think what it is the prosecution didn't make the case. And if you don't make the case, the jury did exactly what the jury is supposed to do in that situation, which is acquit. That's the way our system works. And so I congratulate the jury on what I would call a proper length of deliberative time. They spent time looking at this. They asked for a readback of testimony. I'm not sure whether they got that or not, but they asked for it. They decided the issues in the case. 12 people all agreed. So in my book, the defense ought to chalk this one up. It ought to go on their firm newsletter, and I would suspect that the blonde woman who represented Mr. Griffith in this case is going to be getting a lot more work in the near future. So that's what I have for you today. Thank you so much for watching, and thank my wife for pulling me out to the office this morning so I couldn't get this video made this morning so I wouldn't make a complete fool of myself because I do that often enough anyway. Have a great day. Catch me down here again tomorrow. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.